Welcome to all of you. We're very pleased that you could join us today for the lecture by Bill Colby, who, as you know, is General Counsel of the Truman Medical Centers in Kansas City, Missouri. Mr. Colby represented the family of Nancy Cruzan in their right to die case that was heard by the Supreme Court in 1990. His lecture today is sponsored by the Francis Lewis Law Center, and the topic of his talk is From Nancy Cruzan to Terry Schiavo, The Right to Die in America Today. Mr. Colby is the author of two books related to this subject. One is Unplugged, Reclaiming Our Right to Die in America, a 2006 book, and Long Goodbye, The Deaths of Nancy Cruzan in 2003. Mr. Colby has made numerous public appearances, including being on the Larry King Live Show, National Public Radio, and the Today Show. We're especially grateful that Mr. Colby was able to make time to be with us today while he's here on campus as a parent during Parents Weekend visiting his son Zach, who's a first-year student in the undergraduate school and is somewhere in this audience. I think it's brave of Mr. Colby to do a talk in front of his son in a school setting. I'm not sure I want to do that.
I told you no heckling.
Yeah, okay. Mr. Colby is going to speak for about 20 to 25 minutes. And then Professor Wilson, who we owe appreciation to for arranging this lecture, will open things up for questions. So, without more ado, Mr. Colby, welcome, and join me in welcoming.
Thank you, Dean, very much. Good afternoon, everyone. How are we? Just delighted to be here. This is my wife and my first Parents Weekend ever, so we don't know quite what to do or how to do it, but we're going to try to do our best. I'm taking off the suit after this talk, but really glad to be here and appreciate you all coming out for the talk today. We are from Kansas. It's been very nice. First few months of school, no one has made a joke with my son about he hasn't heard about Dorothy or the tornadoes. Actually, he hears about it nonstop, but Dorothy had left the state many years ago. We haven't seen her for quite some time. Tornadoes we have quite frequently, but none have hit us yet. But here's my plan for the time that we've got. I am going to talk for probably about 25 minutes. I will tell the story of the family of Nancy Cruzan. For those of you in law school particularly, it's an important part of our law that's good to know. I'll try and leave time at the end for questions, answers, discussion about Cruzan, about the law business in general, about hospital law, whatever you might have, I'm happy to answer. Before I get to Cruzan, just to set the background for the talk, I've been working in this area for a long time. I first met the family in 1987, and we spent several years in the court system. Whether it was back then or here with you today, or in the hospital when we talk about these questions, the best way I know to get some sense of how to answer these hard questions is to try to look at them in a little bit of historical context. Done this a lot of different ways over the years, but since we're in a law school moot courtroom, let's do it with a couple of pop quiz questions to start. I've taught at the law school at Kansas from time to time as an adjunct and taught there as a visitor for a year. One of the classes I taught was law and bioethics, which I think Robin teaches here, or maybe Ann. So here's the exam I gave most recently in my law and bioethics class. Last question on the exam. It's a 20-minute essay question. Law students, I'm sorry, I know you've got exams coming up. Sorry to foreshadow those, but I know you didn't go to this class, you didn't read the textbook, that actually puts you in the same boat with 4 students I know who took the exam. So you can't get out of it that way. But here's the law school exam question. Well-known, and it's set in the East Coast, well-known local rabbi driving down the New Jersey Turnpike has a horrible car accident. EMTs arrive. They're able to resuscitate him. They rush him to the hospital, but it's not just any hospital. This is a new joint venture built between the states of New Jersey and Pennsylvania, and the hospital is built straddling the Pennsylvania-New Jersey state line. And as fate would have it, the bed they take the rabbi to that morning in the hospital is the one hospital bed that is straddling the Pennsylvania-New Jersey state line. Medical team does all they can to bring about recovery without success. The attending physician does the various tests that doctors do to see if there's brain activity. There is none. They do 2 separate electroencephalograms, EEGs, where they put electrodes on his head to measure electrical activity. There is none. It's flatline on the machine. It's written in his medical chart as electrocerebral silence. But the rabbi's heart, his lungs, continue to function with all of the mechanical support that we have in the modern day emergency room. Dejected, the doctor walks out of the ER just as the rabbi's brother gets to the hospital, rushes in the front door, sees the doctor and says, "Oh my God, doctor, my brother, is he dead?" What do you think? You got 20 minutes. How many 3Ls here? Show of hands. Not many. They're out looking for jobs already. So this is a question in the last year of law school where when you guys get there, you'll find out, the professors will tell you by that point the answer is almost always, it depends. In Pennsylvania, he is most certainly dead. He meets the state definition of death written in the statutes, which says if you have no brain activity but your heart and lungs are artificially supported, you're defined as brain dead or dead. Interestingly, in New Jersey, he may or may not be dead, depending on what's written in the rabbi's chart about his faith, depending on what this doctor might know about the tenets of this particular rabbi's own religious beliefs. The point isn't particularly at a law school out in the middle of the country, to look at how one state, New Jersey, put an exception in their law to the definition of brain death for religious beliefs. But isn't it interesting, and some of the faculty, maybe more than the students, that could be a serious question on a law school exam? You know, when I started law school in 1979, the word bioethics had just barely... Yes? Too loud? Can or can't?
Cannot. It's garbled, but that would be better.
Oh, this would be better? Okay. Bioethics did not exist. You know, for most of recorded time in the medical world, when we were dead, we were dead. Our heart, our lungs, our brain all stopped at roughly the same time. There was no state anywhere in the country that had a statutory definition of death. There were no common law cases saying that somebody was dead or not dead. Death simply was. Technology has changed all that. All right. Now, as I look out in this room, there's almost nobody on my side of this question. But anybody here ever heard of the television show Dr. Kildare? Ever watched that? Raise your hands. A couple of you I know have seen it. So he was on Tuesday nights from 1961 to 1967. He was the kind of doctor you would want for your family. His success rate was even better than House. I mean, he always got his cases right. But every now and then on that show in the early 60s, Dr. Kildare would run into a hard case, and every time he did, he would turn to a nurse and he'd say the same thing. He'd say, "Go get the bird." Anybody have any guess what he was talking about? Probably have somebody from Baltimore who might say Mark Fidrich. He was talking about a respirator invented by a doctor from California, Dr. Forrestberg. They called it the bird in the hospital. About this big, thick green glass rolling around the hospital on a metal tripod stand. At Bethany Medical Center in Kansas City, very surprising that this happened in Kansas City rather than New York, Chicago, or Los Angeles, but Bethany was the first hospital in the country that had a cardiac ICU. In the early 60s, they had a doctor who had what was then a pretty revolutionary idea. Take heart patients out of their rooms and bed rest, seat them in a central area all together with nurses trained on this technique called CPR, just written about in 1960 in the medical journal, and who could read these new monitors monitoring heart disease and use defibrillators, which had just started to be used on patients. He thought they might have better success with heart patients in that setting. First cardiac ICU in the world. In that first cardiac ICU in 1965, they had a bird ventilator that they were using that didn't have an automatic switch. So student doctors or nurses would sit with the machine and the patient it was hooked up to, and every 6 seconds in a 3-hour shift, they would flip a switch, there'd be a blast of air into the body, and they'd turn it off. And they'd do that for 3 hours, and then the next medical student or nurse would come take over that switch. How often do you think in that first cardiac ICU they were talking about the questions that I'm going to get to in a second about whether it's appropriate or not to use medical technology or whether technology is futile? The answer is never. You either breathed on your own after a couple of days or you died. It wasn't long ago in our culture that we didn't ask these questions. We simply took everything the doctor could give us, and the doctor gave us everything he or she had, because compared to today, it wasn't much. Fast forward today to a modern day hospital. My hospital, which is in the inner city in Kansas City, we've got a CAT scanner. It's one of 5 in the U.S. that takes 100. It's called a 128 slice CAT scanner, where they can get pictures of the brain in 128 different pictures. If something enters your brain, it's just remarkable technology. We've got pills that people can take with cameras in them that take pictures of your insides as they go out. So rather than do invasion, we can then look at the film from that camera when the pill comes out. I mean, just where we've gone today is pretty remarkable. And you think about it, if we've gone from the bird respirator to the modern day in roughly 35 years, those of you who are thinking about legal careers or health law careers, any guess where we're going to be 30 years from now when there are going to be 80 million baby boomers wanting medical care? Not sure that our science fiction writers can tell us, but it's pretty clear to me that we're going to be talking all the time in the years ahead about when to use medical technology, when to stop. And on those occasions when the law gets involved, at the base of that discussion will be the first, and to date really the only time the U.S. Supreme Court has tackled this issue in the case of Nancy Cruzan. So let me spend a few minutes talking about Cruzan, and then, as I say, we'll have discussion after that. Cruzan's case starts out like a lot of stories for a lot of families: a bad car wreck, a phone call in the night from the state trooper that changes life forever for those people. Nancy Cruzan was in a single car accident on a country road just outside of Joplin, Missouri, in January of 1983. She was coming home from work, so we don't know what caused the accident, whether she fell asleep, animal crossed her path, don't know. We do know the basic path of her car from the police and other reports that night. Crossed the center line, went down an embankment, hit several small saplings, hit a rural mailbox, shattered that, shot back up the embankment, was apparently going fast enough that the car became airborne because there were no marks on the road. Farm fence on the other side of the road smashed. Car appeared to flip 3 times, ended up upside down, and she was thrown 35 feet beyond where the car ended up upside down. From where she left the road to where the car stopped was the length of 3 football fields. So we know she was going really fast that night. Neighbor in a farmhouse heard this. He came running out, ran back, yelled to his father. His father came running out. He ran back, yelled to his wife to call the highway patrol. She did. This was 1983 in rural Missouri, so there's no 911. She had to dial, no touch-tone phone either. She had to dial the number, and sometime later, ambulance, fire truck, state trooper all arrived, went to Nancy, started CPR, and they were able to restart her heart. When we reconstructed that story really years later as part of getting ready for the first trial in Cruzan. I concluded it may have been as long as 31 or 32 minutes that she went without oxygen before her heart was restarted. At the very least, it was in the high teens. Every part of her thinking brain that made her uniquely Nancy Cruzan was gone by the time the EMTs arrived. The tissue had not begun to shrink yet, but the damage from the lack of oxygen had been done. They can't know that when they get to a dark farm field. They did just what they're supposed to do. And the family didn't know that as they got the call and spent 2 nights, days and nights, never leaving the hospital. It wasn't until the end of the second day there when her father, Joe Cruzan, finally got up the gumption to say to a nurse, the doctor keeps telling me he's very worried about anoxia, and I'm worried about anoxia too, but what is it? And he started to learn about anoxia, lack of oxygen, and the permanent damage that happens to the brain after just 4 to 6 minutes without oxygen. But that education came to them over time. And if you ask them, like a lot of these families who have been through tragedies like the Cruzans, when they started to lose hope, they couldn't really pinpoint a time. Their lives just changed, and hobbies and vacations and in some cases friends fell by the wayside, and visiting Nancy, caring for her, trying to elicit a response became their lives, became what they did. They did, though, reach a point years after the accident when very tentatively as a family they started to talk about what their options were and what Nancy might want. And they quickly realized they were down to 2 choices only, both of them bad. Accident had taken away all good choices. Predictably, in hindsight, with that amount of time without oxygen, Nancy had moved from a full coma in the ICU. On the 9th day in the ICU, her eyes opened, which was a point of great hope for the family, but brief hope. The doctor said to them, her eyes being open without more doesn't really mean anything. You need to see some interaction. And on the 30th day in the medical records is the first reference to a diagnosis of a vegetative state, which was later changed to a permanent or persistent vegetative state. Kind of eyes open unconsciousness, first written about in the medical literature in the early 70s by a doctor who was seeing more and more of these patients who were brought back from the brink of death, but not all the way back. Our brain stem, where our basic reflexes are housed, breathing, sleep, can go much longer without oxygen and survive than our upper thinking part of our brain. And with modern day accident resuscitation, portable defibrillators, we were creating this new class of patients. But as a young lawyer, the first time you walk into the hospital room of a person in a condition called a vegetative state, it's nothing like you would think about coma or permanent unconsciousness. Nancy's eyes were open. They moved around the room. At times they would appear to stop and fix on you and move again. She could very slightly move badly paralyzed limbs. She would grimace at times. She would groan. Doctors told the family that she did not have consciousness, that she could never regain consciousness. They never saw any reaction that they thought was her conscious self. Doctors said that she could live a normal life expectancy, 40 years in this condition with continued good nursing care, and the only technology in place, remaining in place, a feeding tube they had consented to shortly after the accident remaining. That was one choice. The second was to seek removal of that tube and have that hand in the death of their child. As they talked about those bad choices, it grew clear to them that if Nancy could speak to them, she'd say, given those bad choices, I want the tube out. And that's what they decided they wanted for her as well. They talked to the state hospital administrator. This was 1985 in Missouri. We had just passed 3 years earlier in the state our first definition of death in the statutes of brain death. We just passed that year a living will law, trying to prepare documents where you could deal with these kinds of questions. So it was a new issue in our state. The general counsel of the Department of Health said we've never removed a feeding tube. We can't do that without a court order. So they made the decision to go to court. They were not a family of means. They started scouting around for lawyers who could take on the case as a public service, or what lawyers call a pro bono case. They talked to a lot of groups in and out of Missouri, including a large firm in Kansas City. I started my law practice out in D.C., actually at the law firm of John W. Davis, who named one of the undergraduate residence halls here. I think he was an undergrad at Washington and Lee. And I had just moved back to Kansas City, joined this firm. A senior guy in the firm took the Cruzan case in. He called me and said, this is a cautionary tale I always give to new lawyers. Said, you want to do this pro bono case? Not a big deal. About a half-day trial in probate court. But the issues look interesting. I'm still working on it now, 30 years later. But and I said sure, and off we went. We had and I've never really confirmed. I just joined this firm, large law firm in Kansas City, several hundred lawyers. I'm sure they had some leadership debate at the time where they said, should we take Mr. Shook or Mr. Hardy off the high-paying corporate work that's providing for the livelihoods of hundreds of people, or we've got this new guy who doesn't know much yet and doesn't really have any cases. And I think in that balancing, they decided I had just the skill set that the Cruzans needed for their pro bono case. So off we went. We had a 3-day trial in probate court with the Attorney General of the state and the counsel for the Department of Health on the other side, which we won. They appealed the case directly to our state Supreme Court, where we lost in a 4-3 decision. I decided to petition the U.S. Supreme Court to hear an appeal of that decision, not necessarily hopeful that they would. As some of you no doubt know, the U.S. Supreme Court turns down almost every appeal that's filed there. Typically, year in, year out, they accept about 4 to 5% of the petitions filed, and in the rest of the cases they say, we won't hear your appeal, the lower court decision stands. And they had turned down in the past the very first right to die case from a state, from New Jersey, involving a woman named Karen Quinlan. So we weren't hopeful that they would take Cruzan, but of course they did. And from that day in the summer of 1989, this soul-to-the-earth, blue-collar Southern Missouri family found themselves moving very uneasily right into the middle of a national debate about what was right for Nancy. Lots and lots of groups in society concerned with how Cruzan came out at the court. As again, many of you might know, at all appellate court levels, but particularly the U.S. Supreme Court, groups in society with an interest in a case that's at the court can file their opinion. It's called an amicus, or friend of the court brief. So if the court this week accepts a case that the Washington and Lee Law School is interested in, or a faculty group, or one of your student bar groups, or your homeowners association, whatever it might be, you can file your opinion with the court. You say, here's who we are, here are the number of people we represent, this is our expertise, and this is how we recommend you decide this case that we filed in. In Cruzan, there were over twice as many of those public briefs or amicus briefs as had been filed at the court in its abortion case, Roe v. Wade. Lots of groups supporting the family, American Medical, Nursing, Hospital Association, National Religious, National Ethics groups, almost exactly the same number of briefs on the other side of the case. National Medical Ethics groups. The state of Missouri was obviously actively opposing the family at the time. Our governor then in Missouri went on to become the Attorney General of the U.S., John Ashcroft. And the federal government made the decision at that level to become involved, and they actually split argument time with the state. And the federal government was represented at the court at the time by former federal judge and future Clinton prosecutor Ken Starr. So there were important forces in society on both sides of this case, with this family caught right in the middle. Decision from the court came down the very last day of the term in the summer of 1990. It was a 5-4 decision. 4 of the 9 justices wrote his or her own opinion about what they thought the law was. And for the amicus groups, there was something in there for both sides. New York Times headline said, Supreme Court recognizes new constitutional liberty right. Closer to home, Kansas City Star headline said, Supreme Court decides against Cruzan's. They were both right. The court did say in Cruzan for the first time that all of us in this room, conscious, competent adults, have the constitutional right to make decisions about our medical treatment, including, if we choose, to refuse medical treatment that we don't want. Court had never said that directly before. But Nancy was 25 when her accident happened under the laws of Missouri and really every state. She was an emancipated adult, no longer under the decision-making control of her parents. Court said there's nothing in the Constitution that requires a state, Missouri, to defer to the parents of an adult to make medical decisions. If Missouri wants to insist solely on evidence of Nancy's own wishes before it stops treatment, it can't. Court didn't say this is a good idea or a bad idea. It simply said Missouri's law does not violate the Constitution. So from my point of view, unlike some of the amicus groups, there wasn't much winning in the case that day, and that phone call to the family was a hard phone call to make. The court did, in its opinion, give us an avenue to have a new trial based on evidence that had surfaced as a result of all of the publicity surrounding the case. Lots of people coming to the parents saying, I had this conversation or that conversation with Nancy. So we did have a second trial. Again, the trial court ruled in the family's favor. This time the Attorney General of Missouri made the decision not to appeal that trial court decision. Within minutes, actually, of receiving the court order from the court, Nancy was moved to the hospice wing of the state hospital where she was living. Her feeding tube was removed, and then over the course of the next several days, some of you may have watched it in 2005, the news coverage of the Terry Schiavo case in Florida. Much like the Schiavo case, we saw protesters from around the country arrive in remote hilly southern Missouri. Actually, many of the exact same people that were present in Schiavo 15 years later. Satellite television trucks, obviously not far behind those protesters. On the fourth morning after Nancy's feeding tube had been removed, shortly after 9 in the morning, two large buses of people pulled up in front of the hospital, began streaming into the two entrances underneath Nancy's third-floor hospital room. One was a nurse that had a feeding tube and solution with her. The protesters said they were seeking to gain access to Nancy's room to resume tube feeding. They were stopped by state police. 19 of them were arrested that morning. Later that day, state police locked down the hospital so that you could only enter or exit through one entrance. And over the course of the next 7 days in this remote rural hospital, on some days there were as many as 32 state police officers in the divide between the family and the protesters. So a story that started out ordinary enough in the beginning, car wreck and the phone call, in the end wasn't ordinary at all. It was unique in our culture. And 10 days after her tube had been removed, with her family gathered around, Nancy very peacefully died. When I think about this case and what its legacy is and how long we've been talking about it, so I've been talking about the law and death and dying since 1987. Which is a long time, and it sometimes seems to me like all of society's been talking about these issues for a long time and that we should have them figured out by now. But the reality is, I think that societal discussion is just beginning right now in earnest. Think about these three factors coming together in the years ahead, and think about where you are now in context of these three factors. The first is the demographics of my generation, the baby boomers. Lots of people writing and talking about how many baby boomers there are going to be and how much they're aging. I haven't really found any writing that captures exactly what what our country's going to look like. I've got this picture of the old George Romero Night of the Living Dead movies, but this is going to be Night of the Living Baby Boomers. We're going to be walking, who knows. The best statistic, though, I've heard, the one that brings it home most to me, is from the Census Bureau that says by the year 2030, so 18 years and a couple of months from now, so think about where you'll be 18 years and a couple of months from now, that 43 of the 50 states in 2030 will have the demographic mix of people over the age of 65 that only Florida has now. So in 18 years, virtually the whole country is going to look like Florida. Anybody been to a supermarket in Naples, Boca Raton, West Palm Beach? It looks nothing like your supermarkets here. That's what our entire country is going to look like in a very short time. So that's the first factor. The second factor is the technology. If you read the New York Times science section, the advances in technology, medical technology, and technology every week are stunning. And where we're going to be 18 years from now, we've got no clue. I gave a career talk this morning to the Health Law Society and was talking with a student afterwards, talking about undergraduate degrees. He was basically asking, do you need a science degree to get into health law? My degree with undergraduate degree was creative writing, so I'm not sure you do. But I think any degree, any study that helps you think about solutions to problems, if you can think and communicate about how we're solving problems, that's worth as much as knowing technical knowledge now, because all the technical stuff is going to be different by the time we get to that point. So you've got those two factors, the technology and the aging demographics going straight up, and then you've got the third factor, which is the federal and state governmental money and the private insurance money that all those people are going to want for all that technology isn't going to begin to keep pace. So we're going to be talking all the time in our society in the years ahead about when we use medicine, what the goal is of medicine, and when we stop. And that's a good thing, because the literature is pretty clear that when we talk about this topic, we do it better. It's kind of interesting, and when I think about the boomers coming, everywhere the boomer generation has been as a group, we've sort of wreaked havoc. Voting rights, women's rights, civil rights, birthing rights. Well, who's to say as we come up to our last great rights movement that we're going to go quietly into that great nursing home? I don't think it's going to happen. We're going to be talking a lot about these issues, and as I say, the literature is clear that when you talk, we do it better. And we have birthing classes, we have parenting classes, we have marriage enrichment classes, but the one great uniter of all of us, even here in Virginia, mortality is bumping up right against 100%. It's going to come to all of us at some point. So why would we not talk about it? So I think it's good that the discussion's starting today. And so to kind of close out things before I get to the question and answer portion, I'll bring it back from a bigger picture down to my own family, and not my family that's watching here, but the family I grew up with, because you would think, given what I've done, that if anybody's family could talk about death and dying stuff, it would be mine. But we are as dysfunctional as any of yours. Now, I did not, over the years, go home at Thanksgiving and say, Mom, I'm home, let's update our death and dying talk. But I did one year go with a set of forms in hand and say, we need to talk about this stuff so that we all have a sense of what we want. And I've been in lots of discussions, lots of places, lots of settings, and there's not really a path that these talks follow. Sometimes everyone will talk, sometimes the adult children don't want to, sometimes the parents of the adult children don't want to. In my family's case, it was my mother, who was then in her mid-70s, who said, I don't want to talk to you kids about this stuff. You know what I want. I said, Mom, I've got no idea what you want. She said, well, you'll figure it out when the time comes. I said, great, thank you, that's helpful. So we started in, my adult siblings had obviously followed the Cruzan case. We started talking about Nancy. Our discussion led, as these discussions typically do, to a story. In our case, it was an adult son across the street from one of my sisters whose father got the diagnosis of Alzheimer's disease. Fairly clear path ahead and downhill for his dad with that horrible, horrible disease. And the son and his dad never talked about what his dad wanted until it was too late and they couldn't talk. And then it wasn't so much that the family was in conflict as it was they just muddled through and never felt like they had the right information and never felt like they knew they were doing what their dad wanted. So we talked about what we wanted in that case. We got to the end of the talk. I thought we had a pretty good discussion. One of my sisters said, I'll take this form with me, and one filled it out then, but couldn't engage my mom. And I said, Mom, maybe I shouldn't worry about what happens to you because you don't seem that worried about it. But think about this. Your last act on earth, you've smoked for 60 years. Your last act on earth, you're probably going to lapse into some kind of weird coma or something, and then word will leak out publicly that the Cruzan family lawyer did not have his own mother's affairs in order. So I said, the last thing you're going to do is embarrass me. Do you want to do that? And she said, give me that paper. And I was named at that moment as her healthcare agent. The next day we had the form notarized at the bank in her small town. You didn't have to her state didn't require notarized forms, but I find people lose notarized documents less easily than they do unnotarized. And then over the years we talked about the topic, never in great detail, never in the depth that my friends and family now know about these issues. But when the time came, I had three things. I had the piece of paper, I had the law. I had a piece of paper that said, if this woman can't speak, I speak for her. I had a decent idea of what her views and values were. And then third, critically important, everyone who was going to be in that discussion, in that room, had been brought into the discussion earlier as a family member or a friend. And I think that's that was a pretty good template. So you've got a Thanksgiving Day holiday coming up. Blame it on me. So I heard this lawyer give a talk about this car accident and this happened. Here's what I'd want if I were in that situation. What would you want, Dad? And it's a pretty good talk to have. And then you can do what we do. Put the form away, pull out the Scrabble board, and have a beer, and it's great. So I'm gonna stop there. I've left about 15 minutes, I think, for question and answers. As I said, anything. Free game, so happy to. And Robin, I think, is going to be do the Guy Kibbe thing and moderate. So.
Yeah, I'm sorry.
No,
Go ahead, please.
Okay. What I was wondering, you were talking about the increase in technology, and I was wondering when does new technology become ordinary technology? Is it strictly a matter of cost, that when the price comes down low enough, we consider it routine, that everybody can just have it, or is this something where the technology drives the issue?
It's a great question. For those who didn't hear, and I'll paraphrase a little bit, when does new technology become ordinary technology? When does it become part of the process? I try and think, I talk about that question all the time, but try and think about it in a little bit different way. To me, antibiotics are a remarkable, amazing technology which have changed the course of the entire world. The diseases they've stopped, what they've done, I think they're powerful medicines with a very specific purpose. So, to that end, my views, my values, not for anybody else, whatever, you make your own choices, but if I have advancing dementia, I'm somewhere being cared for, nursing home, wherever it might be, I'm not aware of my family and I'm not going to be again, and an infection comes to me, I think antibiotics are an extraordinary intervention that are not medically indicated for me. Not because they're not. I see medicine's purpose as a bridge to recovery, to live the quality of life that I want to live. And if it can't do that, then I don't want the medicine. I think that's a life-affirming decision. Others may make other decisions, so we have lots of technology, and the discussion about the technology is sophisticated and technical and medical, but there's a whole human side to that discussion which isn't sophisticated at all, but it's difficult. I guess it's not technical at all, and that is, what are we here for? What are people here for? What's the purpose of medicine? When can it serve our purposes? And when does it not? And that's a discussion we really are just starting to have as a society, and it's in a very primitive stage right now. But with those factors coming, we're going to be talking all the time. You all are going to be talking all the time about what you want to spend your tax dollars on. And none of the questions are easy, and they're all about how we live and how we affirm life and what our values are. And part of that discussion will be what's extraordinary technology, what's not. But a bigger part to me is what's the purpose of medicine. And that's true of all technologies. Yeah.
Yeah, I just had a quick question. Before I came to law school, I actually worked for a healthcare company where part of their organization was hospice care. And a lot of the time, when we didn't have social workers available and hospice care comes up with a patient that has really no chance of living beyond, there's no crystal ball, but beyond a certain way where they're just not going to recover from the cancer. They've had 3 rounds of chemotherapy or what have you. Doctors feel so uncomfortable having that conversation with the family. And sometimes they send political science major Chris to come in there and do, they call it an explanation of benefits, where you talk about the quality of care, like what is a last round of chemo going to do for your mom. And it's so much harder when the patient already hasn't had that conversation with their doctor to sign an advance directive. And so a big thing that we would talk about sometimes is, why doesn't the government mandate, like when you qualify for Medicare, you're forced to sit down and have that conversation with your doctor, as opposed to leaving it, not doing it, and now your son is on the line, and feelings of guilt come up, like even if you think it's your mom's wishes, that's your mom right there, and like you're going to tell me I'm not going to give her everything she wants to live. So my question to you is, why don't the states or the government look towards mandating that kind of conversation happening when they become available?
So did people hear the question over here? Basically, it's a great question, and there was.
Could you repeat it?
Oh, for the people in the other room. Yes, sorry, Rob. So again, the question was, having worked in hospice and having those hard conversations at the end, it doesn't work as well if people haven't thought about the issue or talked about it before then, and that's absolutely true. The further upstream from illness in a reflective way that you can have the discussion, the better the information is. And the question was, why doesn't the government mandate or states mandate that conversation happen earlier? If you followed the political discussion with the Healthcare Reform Act, there was actually a very small provision in there to provide reimbursement to internists and general physicians to have that conversation. It was not very expensive, and I think a great way to foster that discussion, to have reimbursement, because there isn't any reimbursement now. And that got morphed in the political process into death panels. And so the idea of paying doctors for counseling became, you're going to try to off my grandma. And it got completely goofed up in the political process, which happens. I'm a fervent believer in the axiom that the cure to bad speech is more speech, not censorship, and particularly in the area of how we navigate our final days and how we do it correctly. In the Terry Schiavo case, there was so much misinformation and bad science and just factual inaccuracies being talked about on television every night, but it at least caused people to talk. So I remember talking to a law group in, I can't even remember where it was, maybe Nebraska, and somebody said to me, how can you say that about Terry Schiavo? I see her on TV, and she's obviously interacting, and you're just what you're talking about is discriminating against the disabled. And I said, well, first, I'm only talking about my own choices, and I think you have to make your own choices. Second, I've read all the medical records, and I'm not sure you have the science right. But even if you do, Think about, so the most optimistic doctors in the Terry Schiavo case said that she may be just slightly outside of a vegetative state. She may have some primitive consciousness, not going to improve beyond that state. What if you're in that state? What medical care do you want? We shy away from these questions because they're hard and they're, but the easy societal questions get solved by people who aren't lawyers. I mean, that's part of, for you, those of you who are law students here, that's part of the great gift that we get to do as lawyers. We get to help people navigate questions that they can't figure out on their own. And this, the question about how we live our last days is as fundamental a question as you can have. But to your point exactly, I've been involved in those discussions in hospitals where the family hasn't talked at all, and your experience here may be different than mine in the Midwest, but I find that families that didn't communicate well before crisis don't turn into the cleavers when moms, it's profoundly hard. So to the extent you can have that hard discussion upstream from illness and get hospice involved more than 7 days before the end of someone's life, I just think it's a gift. And to think that we can avoid those discussions, I think is just wrong. We will have the discussions, so it's just a matter of how much information we have when we do.
Do you think that with the aging population and the improvements in technology, it could, the realities of healthcare could get to the point where your choice kind of becomes a secondary issue to just the allocation of healthcare? Is this, I mean, such that so many resources would be diverted away from, the more traditional ideas of healthcare and towards, maintaining, I guess, a vegetative state.
It's a hard question to even ask, isn't it? And it's a great question, and it is, as we have more technology and more aging people, are we going to start having discussion in society about how we allocate resources and who deserves medicine and who doesn't? We already do that discussion to some extent. Organ donation, allocation by default. I have people come into our, so we're an inner city hospital system. We provide about $108 million a year of indigent care for people who cannot pay, but a lot of those people can't get the care they need, so they don't get medicine as they need it and end up having a heart attack coming through to the emergency room. We've allocated care in that way, but I think we're going to be talking a lot about that question. And take feeding tubes as an example. Feeding tubes are a bit of a lightning rod because people think of feeding. Well, that's the nurturing that you do with people. Certainly you would never take feeding away from someone, but what is a feeding tube? Is that the feeding that I do for my 4 children who are thriving and growing, or is it an FDA-regulated nutrient being pumped into a body that's lost a God-given ability? We've got to have that discussion, and we this answer. Let me just lengthen it out a little bit, but to tie the law into it. When we were involved in Cruzan, one of the opinions written at the court was by Justice O'Connor, and she wrote at length about feeding tubes and what the nature of feeding tubes was, and we debated that some in the case. We were talking about the kind of feeding tube that Nancy Cruzan had, placed in 1983 in the operating room under full anesthesia, surgical incision, tube surgically placed, used very rarely, first one ever placed, used very rarely, usually for accident victims, drowning, near drowning victims, people who might recover the ability. And that's the kind of feeding tube we were debating in the law in Cruzan, and that Justice O'Connor said it's a medical treatment like others. But as happens so often, technology passed the law by as we were having that discussion. 2 docs at a children's hospital in Cleveland, concerned about how invasive the surgery was for their pediatric population, came up with the idea of a PEG tube, percutaneous endoscopic gastrostomy. I don't have my medical degree. I've seen one done. You wouldn't want me to do it, but it's pretty simple. Pinprick in the stomach. You put the endoscope down through the mouth, so it's a light and a clamper, and you put a thread through the stomach. The clamper comes down, finds it, pulls the thread out, tie a feeding tube on. Voila, you've got a feeding tube. So we're talking about this surgery. Technology passes us by. In 83, that technology was adapted for adults. We started to place peg tubes in adults. And now, according to the medical literature, to answer your question, last year we placed 275,000 peg tubes in people over the age of 65, many of them in people with dementia, unaware of the world around them. I'm not saying it's a good idea, bad idea, what my views are, but I think we have to have the societal discussion about, and it can't, on one level it can't be at a society level, it's got to be at an individual level. I think my family, poor people have heard about death and dying more than any sane people should. But when the point comes, if I'm at that place and a young doctor says to my wife, well, you can't really say no to a feeding tube, that would be considered starving your husband to death. She'll say, well, first get your medicine right, because dehydration comes long before starvation. And second, for him, the whole purpose of medicine, whatever it might be, is so that you can live. And he doesn't think that in this state that's appropriate. So we have to have that discussion. We also have to be very mindful of the other side of the discussion, which is our country, people generally. There's a long history of the rights of the disabled not being honored. And we have to find the appropriate way to use medicine in our society. And the only way we're going to do that is through open, thoughtful discussion about what the purpose of medicine is.
I think we have time for one more question.
Yeah, Mr. Colby, first of all, thank you again from everyone, I assume, for coming out here today. I know we've talked a lot about sort of technology being used as a way to sustain life and just sort of elongate how long people can live. George Romero sort of example is pertinent here. But I was wondering if what your thoughts were on the countervailing medical technology, which can sort of determine more about brain function and about body activities and sort of more of the science behind what makes somebody really alive. Is that something that's going to eventually make this kind of question sort of obsolete in a legal context, or is it so circumscribed by issues of morality and philosophy that that's never going to happen?
I'm glad we're ending on the easy questions. Just to summarize, fitting technology into how we make decisions. Will some of the decisions become obsolete as the technology advances? I think they'll grow more complicated in a way, just as the technology grows more complicated, but they'll always be tied to the fundamental. I mean, there's a lot of art that goes with medicine. There's a science, but there's a lot of art that goes with it. And you think about the mystery of being dead or alive. The fact that, I mean, that exam question we started with, that because of your one person's religious belief in how life exists and when it starts, you could have science saying to a family that your family member, the rabbi, is dead because he has no brain activity, and as part of your religion say, but the heart is part of what makes a person alive. So there's an art that comes with it too. So I think we'll have to learn the technology and assess it, but the fundamental questions about what are people for and why we're here will always be part of that discussion. And I think they're just, those will stay the same. The technology will continue to advance, and I think it's going to grow. I think it's going to grow harder and more interesting. So it's good that you all are starting to think about this stuff today, because it will not be the last time you have these discussions. Hey, thanks for having me. Really appreciate it.